complaint alleges that another mass deportation flight is in the works as we speak, even as the U.S. and Iran have resumed shooting at each other over the Strait of Hormuz.
Yeah, it's amazing how we're bombing this country. You know, Trump is threatening to bomb the country into the Stone Age. At the same time, he's like, and here are all of the refugees.
Here are political prisoners in opposition to the government that we're at war with.
Welcome to Law and Chaos, where Florida's Stop Woke law got stopped. Graham Plattner is GTFO, and the U.S. government is handing Iranian asylum applicants over to the Iranian government because we are most definitely the baddies. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
Well, I'm mostly good, except we need to pour one out for Bonnie Tyler, who passed away today.
Oh, I know. You guys have no idea how much this man loves Bonnie Tyler.
I do and always will. So
total eclipse of the heart. That's you, sir.
It's a heartache.
Okay. We have a million stories about Iran and Stop Woke and subpoenas in Georgia. And for subscribers, we'll talk about the next chapter in Judge Fight. But first,
dun, dun.
1 million docket alerts. Okay. We often say on the show that Donald Trump is making new law all the time, and he definitely is. For instance, on Wednesday, he posted that he's going right to the Supreme Court to tell those justices they better reconsider the birthright citizenship case.
Yeah, that decision, Trump v. Barbara, was 5-4. Clarence Thomas's dissent laundered absolutely garbage, bad faith, non-legal takes from dishonest right-wing loons trying to launder racism into the 14th Amendment. So yeah, right-wing Christian nationalists are going to keep trying to undo the Civil War, but not like tomorrow.
Well, conversely, signs and billboards are being put up all over our southern border and Mexico advertising birthright citizenship with deliveries starting at $4,000. Likewise, similar signs going up all over our country. Billions of dollars will be illegally made by this scam, with citizenship going to anyone willing to pay. It will be by far the number one way of becoming a citizen. And then the entire family will be allowed to follow. Not sustainable. Nobody saw this coming. American citizenship is not for sale. In fact, this is a crime, and therefore the Supreme Court's ruling is wrong. I will be asking for a rehearing by the United States Supreme Court immediately. This miscarriage of justice will destroy America if they don't change their absolutely insane decision. Thank you for your attention to this matter, President Donald J. Trump.
American citizenship is not for sale. This man literally invented $1 million Trump gold cards that look like little credit cards with his stupid Sharpie signature on it that foreign nationals can buy to get authorization to jump the queue, live, work here, and get first consideration for citizenship. Like, the Trump administration is selling citizenship and, frankly, everything else to the highest bidder.
Well, yes, but I think you're kind of missing the point here. Like, the man thinks you can appeal a Supreme Court decision to the Supreme Court immediately. That's not a thing.
No, and speaking of not knowing how the Supreme Court works, I guess now is as good a time as any to talk about E. Jean Carroll, because that is another instance of Donald Trump trying to say, I'm appealing a Supreme Court decision to the Supreme Court. And that effort imploded on impact with actual courts of law.
Right. We've talked a ton about Trump's petition for cert getting denied on June 29th in the first E. Jean Carroll defamation verdict. Since 2023, when that verdict came down, there's been $5 million plus the 11% statutorily mandated interest held in a court escrow account at the Southern District of New York. Carroll and Trump agreed that after a final disposition, either a ruling on the merits by the Supreme Court or denial of cert by the Supreme Court again, the court would release the money to Carroll. But Trump said that actually that didn't mean Carroll should get paid because he's actually going to ask the Supreme Court to reconsider its denial of cert, which A, that's not a thing that ever happens. I mean, you can ask them to, but they don't ever do it. And B, even if they did, that would not entitle Trump to a stay of the judgment in the meantime.
Yeah, you cannot overstate that first part enough. People don't even ask, because the last time the Supreme Court reconsidered its denial of a petition for certiorari was on very narrow procedural grounds. On the merits, it does not happen. And To your second point, Supreme Court Rule 16.3 explicitly says the order of denial of a petition for a writ of certiorari will not be suspended pending disposition of a petition for rehearing, except by order of the court or a justice.
So last night, Judge Lewis Kaplan, the trial judge, said, no, we're not doing this. He said, in the last analysis, defendant has been stalling this case for years. A jury unanimously concluded that he sexually abused and defamed plaintiff and awarded her damages accordingly. The judgment on that verdict has been upheld on appeal. En banc rehearing has been denied. The Supreme Court has denied certiorari without dissent. It is time for him to do equity and pay the judgment.
And then today, the Second Circuit essentially agreed. Donald Trump's lawyers had asked for an administrative stay while they consider his appeal, and the court denied that administrative stay.
Time to pay up, asshole.
I really did think that Trump was going to file an emergency request for stay at the Supreme Court.
I mean, he still might, right? As of now, he has not. I've spoken to a few people, and they say it takes a few days for an order to wire money out of the court's escrow account to get it to somebody's account. By the beginning of next week, Carroll should actually get the cash, but I mean, I guess he has a couple of days.
I mean, it is about damn time for that woman to get paid.
Absolutely. Okay, next up, Trump's Kennedy Center Stooge Board lost a fight at the D.C. Circuit to slap his name back on the institution. The three-judge panel, including Judge Gregory Katsas, a Trump appointee, agreed together. There was no grousing in dissent. The court said that the argument about all that wasted effort in taking Trump's name down was moot because he's already down.
If a court orders you to do something within 14 days, and then on the 14th day, you race to the appeals court with a request for relief within the next 10 hours, which is what they did. This is generally what happens, right? Like the court will treat your delay as a sign that is not actually an emergency. And by the time they consider it for real, you've already complied.
Right, exactly. And there were additional grounds that they laid out in a very short order. They said that there was no evidence that removing Trump's name from the facility would harm fundraising. I mean, maybe it will, maybe it won't. But since the DOJ can't be bothered to present any evidence of this claim, no one knows. And courts aren't going to rely on just a conclusory statement. And look, we talk a lot about how this Justice Department is not doing real law. Yeah. And here's how that looks on the ground. So in its request for an emergency stay, the Kennedy Center Stooge Board argued that taking Trump's name off of the place would cause irreparable harm because the board would have to give back all of this money that it has raised. They said that somewhere along the way, and they did not say when.
Pointedly.
The board had passed a resolution requiring the return of all donated funds if Trump's name was removed. So it looks like they tried to slip a poison pill into the bylaws. Yeah,
but more like threatening to shoot the hostage. Right?
Yeah.
As board members, they voluntarily added language to their bylaws threatening to kneecap their own institution if they didn't get to do something that a court had already ruled was illegal. We suspect, based on the spelunking work that you did actually for a written post, that this is the grossest breach of fiduciary duties of the trustees of the Kennedy Center. And right after the judge had already said that they breached their fiduciary duty by shutting the place down without considering the statutory mandate to serve as a center for the performing arts or to consider the cost to the long-term health of the institution.
Right. And on top of that is the shit lawyering that went on here, right? Like, you can't raise new arguments on appeal. That's just, it's categorically not allowed.
Particularly when your claim is that the trial judge abused his discretion. I mean, definitionally, a trial judge cannot abuse his discretion by failing to consider evidence that you never presented to him.
Yeah, which is exactly what the court said. So too bad, so sad. Trump's name stays off of the Kennedy Center. And meanwhile, the Stooges will have to explain to the trial judge on July 28th why those idiotic drapes covering up the fact that Trump's name has been removed are still in front of the building.
I mean, to hide a petulant old man's shame. We all know why they're still hanging.
Well, obviously that. But again, what are they going to say in the court? I mean, from a practical perspective, I doubt that Judge Cooper would tell them to take them down, right? That would be micromanaging an institution. Judges don't like to do that.
Yeah.
But as we've said, the Justice Department lawyers are in a terrible position, right? What are they going to get up and say here? Like what are they going to say? The drapes are there because Trump is a spiteful dick? I mean, no. And I mean, if they could, there's something that the court could probably do about it, right? The courts just don't like to interfere with executive branch agencies.
Let me draw that out, right? Like, the plaintiffs are not going to request, and the trial judge is not going to order that the TARP come down. But what the trial judge will do at that hearing is say to the DOJ lawyer, whoever is there to argue, Brett Shoemate, whatever, Mr. Shoemate, why is that TARP still up? And he will have to answer as an officer of the court and get grilled.
Right.
And that is the leverage that the judge has. And by the way, this is a thing we say a lot, but this is yet another reason why you don't go to work for Donald Trump. Also, because you might wind up having to walk into a court and indict an Olympian for vandalizing the reflecting pool just to assuage your boss's ego.
Yeah. So David Hearn was indicted in D.C. Superior Court this morning. He's the former Olympian who was out riding his bicycle and stuck his hand into the reflecting pool and touched the peeling paint and was then arrested a couple of weeks ago. Note that U.S. Attorney Jeanine Pirro decided to go to a municipal grand jury, that is the D.C. Superior Court, rather than one convened by the federal court, the U.S. District Court. Presumably, Pirro wants to keep everything that she does as far away from Chief Judge James Boasberg as possible, since Judge Boasberg keeps calling Pirro's office out for harassing the president's opponents and putting a stop to it. I mean, he's blocked multiple investigations, most notably of the Federal Reserve Chair, Jerome Powell, former chair. Remember, D.C. is not a state, so the U.S. attorney, in this case, Jeanine Boxwine Pirro, runs most of the city's prosecutions, and she has the choice whether to seek an indictment from a federal grand jury or a municipal one. She's had slightly better luck with municipal grand juries, as evidenced by the fact that she got one to vote for this indictment.
Yeah, you are not kidding. This is a very thin indictment. In fact, I'm going to read it in its entirety right now. On or about June 19th, 2026, within the District of Columbia, David Carter Hearn maliciously did injure, break, and destroy certain property, that is, lining material of the Lincoln Memorial Reflecting Pool, property of the United States government, causing damage in the amount of $1,000 or more. And that just tracks the words of the relevant statute, which is D.C. Code Section 22-303, and says, yeah, Hearn did that. I mean, this is as bare bones as an indictment can get. But by the way, 22-303 carries a maximum penalty of up to 10 years in prison.
Which is terrible, but I believe that this case is pretty clearly doomed. Honestly, I think it has the potential to blow up like the Broadview 6 case in Chicago. That's the one where they...
say more.
Right. Well, so that's the one where they tried to indict protesters for felony conspiracy, only to reveal systemic prosecutorial misconduct before the grand jury in the U.S. Attorney's Office. Pirro has had, as we said, a hell of a time securing indictments from the federal grand jury. She keeps getting no billed because she brings in garbage cases like this. If federal judges in the U.S. District Court accord her no presumption of regularity. And now she's rocking up in municipal court with this facially goofy indictment. I mean, I don't exactly know how this case is going to implode, but I feel reasonably confident that it will.
Yeah.
Okay, we're going to take a quick break and then come back and talk about former Wisconsin Judge Hannah Dugan.
And we're back. Before the break, we were talking about political indictments. And speaking of, former Wisconsin State Judge Hannah Dugan was sentenced yesterday after having been convicted by a jury of obstructing ICE agents in their official duties. Judge Dugan is the judge who let an immigrant defendant leave her courtroom via the jury door and not the public hallway. That defendant was arrested anyway, within like 5 minutes.
Right. There were ICE agents in the hallway that she had tussled with, sort of not physically tussled, but she had yelled at them and said, get the hell out.
Right, because ICE is showing up in state court when defendants have to be there on other matters and then arresting them the second they get out.
Have to be there unarmed, right, by themselves. Yeah.
Right. So, somewhat disturbingly, in my view, Judge Dugan was indicted and convicted by a jury, and the government sought a significant custodial sentence, right? That is, the government asked for 8 to 10 months in prison for Judge Dugan, and the presiding judge, Lynn Adelman, said, no way. He said, This, meaning the conviction, is for a few minutes of conduct for someone who has otherwise dedicated her life to public service. It is a marked deviation from an otherwise law-abiding life. And he gave her a $5,000 fine.
I mean, it's still bullshit. I have no idea how this conduct in her own courtroom was not part of Judge Dugan's official duties and thus immune from prosecution.
Newer do I. But I am relieved that she doesn't have to serve time.
I mean, it's something.
Yeah.
Okay. It is time, friends, for the Law and Chaos Doofus of the Day.
You doofus!
Texas Attorney General Ken Paxton, come on down.
It's always the ones you most suspect, honestly.
Yeah, if you were like, which politician running for Senate in Texas would spend 4th of July in Europe with the Christian influencer who broke up his marriage? I would definitely, if you said which one, I'd say Ken Paxton.
Props to Democratic Senate candidate James Tallarico's social media team. They posted the photo of Paxton and his girlfriend next to an image of Tallarico with Willie Nelson, with the caption, James Tallarico spent the 4th of July in Texas with an American icon, Willie Nelson. Ken Paxton spent the 4th of July with the British.
Yeah, sometimes the best joke is the one you don't say. You just let everyone think, right?
Counterpoint, it's funnier when you explain the joke.
Okay. I mean, look, I'm not here to police anyone's marriage, and that's why this dude is... and that's not why this dude is our doofus, because of his vacation. Although Paxton's marriage is directly relevant to his doofus-tude. Turns out Paxton has been voting in Collin County using the address of his former marital home, a home he has not lived in for the last 2 years. ProPublica reports that he appears to live in Denton County in a house purchased by a trust affiliated with his family.
Yeah, I'm glad you made that point and drew it out, because Ken Paxton routinely, every single day, threatens to lock people up for voting illegally, and here he is doing that exact same thing for 2 straight years.
What a doofus of the day.
Texas, you know what you got to do.
Yeah.
Okay, we do have a few more important stories that we want to cover in this extended docket alert segment. The first is out of the 11th Circuit, where the attack on academic freedom in Florida's Stop Woke Act got bench slapped out of existence.
Okay, so in 2022, Florida passed the Stop Wrongs to Our Kids and Employees Act. Get it? Woke, get it?
If you're not doing the acrostic. Anyway, sorry. Florida.
So the law purported to ban all manner of wrongthink in schools, workplaces, and universities. This god-awful attack on primary education remains in place. Teachers in Florida can't teach anything that makes students feel guilty for being white, whatever that means, and they can't have pride flags in the classroom.
Yeah, feel the freedom.
But the ban on diversity training was blocked for violating the First Amendment, and that was indeed upheld by the 11th Circuit last year. And then on Tuesday, the 11th Circuit upheld the order, the trial judge's order, blocking the bans on speech in higher education.
Yeah, this law was wild. It set out 8 banned concepts relating to race and sex. It said that professors can't teach in a way that, quote, espouses or, quote, endorses that systemic racism exists, which, by the way, systemic racism exists.
Yeah.
That people carry unconscious bias, which we have proven scientifically they do. That anyone's moral character is tied to their race or sex, or that being colorblind is itself a racist concept. Professors are, to be fair, still allowed to discuss these ideas, but only in what the law describes as, quote, an objective manner, and only, quote, without endorsement. So I guess a professor can describe critical race theory in like a Ben Stein monotone, but the second they sound like they actually might believe it, they're in legal trouble. And enforcement runs through private complaints. So if a student, a colleague, a rando in the back flags you, the university has to investigate under the law. And if you, as the professor, do not correct your teaching, you can be fired. Willful violations put a university's entire state performance funding at risk. So it's not just watch what you say, it's watch what you say, or we will smuggle in a plant from Liberty University that's a transfer student to bankrupt your whole institution. And the state's legal justification for this nonsense was that Professors are state employees, and so whatever they say in the course of their employment counts as government speech, because if you work at Walmart, your employer can indeed restrict you from, let's say, proselytizing your fellow employees. Ipso fatso, when the state is your employer, it too gets to dictate what you can and can't say at work. So Florida says it can tell teachers what to say in the classroom.
Pay no attention to decades of Supreme Court precedent saying that the First Amendment absolutely protects academic freedom.
Well, Florida sure didn't. I mean, it just tried to argue that the legislature needed to grossly restrict professor speech in order to combat discrimination and protect what they call, quote, cherished ideals, whatever that means.
Oh, I think we all know what that means.
Fair. So anyway, the 11th Circuit said, no, the university classroom is not a Walmart. Hearing ideas that you disagree with at a university campus is not discrimination. This law cannot stand. The opinion was written by Judge Britt Grant, a Trump appointee, and joined by Judge Charles Wilson, a senior judge appointed by President Clinton. Barbara Lagoa, a Trump appointee who is always on the long list for Supreme Court vacancies, dissented.
Oh, she's always a bridesmaid, never a bride. She is never going to be on the Supreme Court.
She got a lifetime seat on the 11th Circuit. Ugh. So, she's doing all right for herself. She's fallen upwards quite a bit. Anyway, Lagoa bought into the government's theory, hook, line, and sinker. She thinks college professors need to make like Walmart greeters and just wave people along benignly, never challenge anyone's thinking or express an opinion. And Grant, to her credit, just trashed this opinion, right? Like, seriously, Control F'd it, the word dissent appears 65 times in this opinion, and most of those 65 appearances are Judge Grant saying things like, we are sincerely confused by the dissent's insistence that Bob Jones University v. United States has any bearing on this case. Bob Jones upheld an Internal Revenue Service ruling revoking the tax-exempt status of private universities that refused to admit applicants who were part of an interracial marriage or spoke in support of interracial marriage. That case was not about free speech, and this case is not about racial discrimination.
I mean, Judge Lagoa's dissent is pretty ridiculous.
It is, but I also want to be clear. Judge Grant's opinion really is quite thorough in laying out just how badly the government mangled the law, trying to sweep everything a university professor says under the mantle of government speech. It says, neither the defendants' cherry-picked quotations nor a true government speech analysis, which the defendants disclaim, supports their far-reaching conclusion, and the combination of the two fares no better. 0 plus 0 is still 0. The defendants' mashed-up theory of government speech results in an astonishing assertion. If the government pays your salary, it can dictate every word you say as part of your job, even in the academic context. And Florida leans into this assertion rather than minimizing it, agreeing at oral argument that a state legislature could constitutionally ban any negative classroom statements about a particular gubernatorial administration. We give the state credit for not feigning limits that its theory lacks, but the chimeric government speech doctrine it conjures cannot withstand constitutional scrutiny.
Yeah, I am sure that the state will appeal, but this law was passed around the time that Texas and Florida were in tandem churning out all of these crazy speech bans when Biden was president. That was when the state tried to make it illegal for social media platforms to deplatform, to kick off politicians or other people who spread misinformation. And the Supreme Court eviscerated that law, and many of the other ones kind of died at the 11th Circuit or died at the trial court because they were all ridiculous. I do not think there will be an enormous appetite to get bollocked again by the Supreme. I mean, even Judge Kavanaugh, I think that it was like a 7-2 the last time that they wound up at the Supreme Court with one of these really ridiculous First Amendment laws. I think that was Net Choice v. Moody at the Supreme Court. And I don't think that they would want to go back for another round. The other hand, Florida's current Attorney General, James Utmeyer, is a crazy sumbitch who thinks that he's going to be president one day. So who the hell knows?
It's true.
Okay, let's move north to Georgia, where the FBI is hot on the trail of anything it could find to make Trump's lies about the election fraud in 2020 seem like they are true. which they're not.
No.
MS Now reports that Kash Patel, the FBI director, is surging 260 agents into Atlanta for what is being referred to as record checks associated with voter information seized from election officials in Fulton County.
Thank God the FBI solved all crimes, and now we can spend millions of dollars and man-hours on this shit.
Yeah. So relatedly, the DOJ served a huge subpoena on Fulton County elections officials demanding the names, home addresses, personal cell phone numbers, and emails of basically every poll worker who touched the election in any way. It said that the records should be emailed to Dan Bishop, the U.S. attorney in the Middle District of North Carolina, who has been installed to run election integrity investigations nationwide. So the county moved to quash the subpoena, arguing that it was clearly launched for political purposes, and the case landed on the docket of Judge William Ray, who is also a Trump appointee, and he granted the motion to quash, but not because the subpoena was served for retaliatory or inappropriate purpose. He didn't really get too far into that, although he kind of said it sure looks like it.
Right.
But he said that there was an easier, more proximate reason to quash the subpoena, and it was that it is far too late to charge anyone for crimes associated with the 2020 election, even if such could be proved. He said, so, is there anything wrong with the DOJ using the grand jury to subpoena these records from Fulton County? In this court's view, yes. These records, even if they lead to the DOJ finding individuals who worked for Fulton County in the 2020 election who support the theory that the 2020 election was not fair, would not lead to information that could be used to charge anyone with anything, at least not any viable charge. That is because the statute of limitations for any possible crime arising from the 2020 election has long expired, as the DOJ must have brought such a case, if it could, no later than late 2025 or the early weeks of 2026.
Yeah, the government had a lot of, frankly, crap arguments to try and get around the statute of limitations problem. They said, well, maybe there was a conspiracy after the fact to cover it up. We've talked about how the government has taken that approach in with respect to a grand jury convened in Fort Pierce.
Right. To get, to try and get the Mueller investigation and Jack Smith, because they're all part of one conspiracy.
Right. And no, you can't go looking for a time-barred crime to invent a conspiracy around. But actually, my favorite wackadoo argument that the government came up with here was that the statute of limitations isn't a jurisdictional bar to charging someone with a crime. It's just an affirmative defense.
What?
And yeah, did you actually go to law school? I know you did. Yeah. I mean, the lawyer who would say such a thing? And just to draw that out, an affirmative defense is like when you shoot someone and you say, I shot them in self-defense. You then, as the defendant, bear the burden of proof. The government doesn't have to prove beyond a reasonable doubt the opposite of that. It completely shifts the burden. And that's not what the statute of limitations says. The government may not bring a criminal case after a certain period of time has elapsed.
It's 5 years, right? Yeah. Here it's 5 years, and we're done, right?
Judge Ray was actually, I think, all things considered, pretty nice about how he dealt with that argument. Here's what he said. In essence, the Department of Justice's argument is that it would be proper for a grand jury to investigate a time-barred crime, indict a defendant or defendants, and allow pretrial procedures to begin when the conclusion is inevitable. The statute of limitations on the relevant crimes has already run. Therefore, the DOJ asks the court to use its already scarce judicial resources on what would be a dead-end prosecution. The court is not convinced that it must ignore the clear existence of a time bar against any hypothetical crimes.
Yeah, I mean, he's calling out the waste of judicial resources, and he's sideways calling out the waste of prosecutorial resources, of government resources. What the hell are you doing trying to find a crime from a long time ago that can never be charged, and surging agents into the state? It's just a waste.
I think he's coming close to the line of saying, I will not let my court be used for political retribution. He didn't say that. I wish he had, but came close.
And a Trump appointee in a very purple state.
Yeah.
Okay, so there will be no giant fishing expedition. Kash Patel's goons will have to go spelunking somewhere else to find evidence of the fraud they are very super sure exists, except no one can ever prove it. Okay, we will be right back to talk about crimes against humanity.
Yay.
Yay.
Not the card game.
And we are back. On July 7th, the Iranian-American Legal Defense Fund filed a bombshell lawsuit suing Secretary of State Marco Rubio, DHS Secretary Mark-Wayne Mullen, Acting ICE Director David Venturella, and their respective agencies under the Administrative Procedure Act, challenging the government's asylum policies.
Asylum applications are governed by 8 U.S.C. Section 1158, which says that the Attorney General may grant asylum to a refugee defined as a person who faces a well-founded fear of persecution on account of race, religion, nationality, membership in a political social group, or political opinion if they were to be returned to their country of origin. And before we talk about the law, I want to give you some numbers, right? The State Department reports these numbers on the fiscal year, which starts on October 1st of the previous year. So in fiscal year 2024, which started October 1, 2023, that was entirely under President Biden, we admitted just over 100,000 refugees. In fiscal year 2025, that's 3 months of Biden, October, November, December, and 9 of Trump, that number dropped to 38,000. In the 9 months in fiscal year 2026 so far, we have granted asylum to just 7,730 people. That is the lowest total since the State Department started keeping statistics back in 1975, and by a lot, by almost an order of magnitude, right? And as the capper, of those 7,730 admitted refugees, all but 3 have been white South Africans. The other 3 are 3 Afghani refugees who were admitted back in November. None since. So in other words, we now have a whites-only asylum policy in this country. If you are a person of color, even if you face persecution, torture, death, even if you've risked everything to try and come to this country, this administration has sent you back to your country of origin.
So this complaint alleges that beginning in March 2025, the State Department secretly reached out to the Iranian interest section, that's their diplomatic representation in the United States. It's actually housed inside Pakistan's embassy because we do not have an Iranian consulate in the United States. We don't have consular relations. The complaint says that we asked for Iran's help in deporting Iranian nationals in this country who were seeking asylum. And it says that when the Iranian officials asked for a list of detainees, the U.S. representative handed over 150 names on the spot. And that initial disclosure grew into monthly meetings between ICE and Iran, during which ICE shared detainees' immigration files and asylum applications.
I know we're running out of ways to say how unbelievably evil this administration is, but this is so incredibly evil, right? The complaint also alleges that ICE arranged in-person meetings between those Iranian officials and detainees to be deported without their consent. Those detainees reported that when they got into those involuntary meetings, the Iranian official in the room already knew the details of their asylum claims, right, which is what supports the inference that they had illegally turned over those asylum applications. The complaint says Iran even got to pick who went on 3 separate mass deportation flights that were launched in September 2025, December 2025, and January 2026. And the capper, ICE continued to hand-deliver dossiers to the Iranians even after the U.S.-Iranian war began in late February of 2026.
Yeah, and let's be clear. I assume that many of these Iranian refugees were seeking refuge because they are LGBTQ+, where they're not safe in their home countries. So outing them to the government is effectively signing their death warrants in some cases.
Yeah.
The lawsuit has drawn Judge Ana Reyes in D.C. We've talked about her a lot on the show. She is the judge who enjoined the anti-trans policy in the military, found that it was totally shameful and retaliatory and had nothing to do with any actual military purpose. She's very tough. She's a very tough judge, and she works her ass off. Yeah. you better come correct before Judge Reyes.
Yeah, on both sides. I think that's right. So this complaint alleges that the secret policy of turning over information to Iran violates the Administrative Procedure Act. That is 5 U.S.C. Section 706, subsection 2A. And that standard, we've talked about this a lot on the show, is that if an administrative agency's actions are contrary to law, arbitrary and capricious, and or an abuse of discretion. And here's the argument. That is, the plaintiffs allege that this policy violates two sets of binding regulations. The first is 8 CFR section 208.6a, which bars disclosing information contained in or pertaining to asylum, withholding, or applications pursuant to the Convention Against Torture without that applicant's written consent. Right? We have said, if you come here and petition for asylum, we will keep that confidential unless you voluntarily and in writing agree to release that information, because, as you pointed out, Liz, this is often incredibly personal information about why you face persecution back home. They also allege it violates 8 CFR section 236.1e, which specifically prohibits officers from revealing to consular officials that a particular detainee has applied for asylum, right? We also keep the fact that you filed an application secret. The point of these rules collectively is that outing someone as an asylum seeker to the government they just fled from is dangerous not only to the applicant, but also to any family members they may still have in the country. Like, this is an international war crime.
Yes, it absolutely is. In court, however, we expect that the government will try first to get rid of this case by challenging the Iranian American Legal Defense Fund's standing to bring suit at all.
Yeah.
As of right now, there are no plaintiffs who have personally been deported. So the IALDF is asserting what's called organizational standing, and it's partly that you, the organization, are kind of standing in for the interests of your members, and also that you are you have wasted your own resources, right? That you can't you are so busy dealing with this problem that the defendant has created that it is a drain on your resources. That's kind of and that is what they use as a evidence of concrete injury to challenge the policy.
Yeah, and over the past 30 years, the Supreme Court has continued to narrow the scope of what constitutes organizational standing, right? You now have to demonstrate as an institution that you have suffered concrete injuries as a result of the policy. It's not enough to just say, we represent and advocate the interests of, for example, potential Iranian deportees here. That used to be the law. And, in my view, still ought to be the law. So the standing allegations that are present in this lawsuit is that the Rubio policy destroyed client trust between the IALDF and its potential clients, right? That it forced them to undergo revised intake protocols. It forced them to undertake a different kind of risk counseling to their clients, to implement alternate safety planning measures, and to bring out new referral procedures. And all of that concretely cost the IALDF money. It had to shift funds away from its core mission in order to react to this policy. So, I think you're right that that's where the government is going to try and get this thing kicked. And we're just going to have to watch to see what happens.
Okay, so in terms of relief, the plaintiffs not only want this policy by Rubio declared unlawful and vacated, they want Judge Reyes to appoint a special master to review which detainees' files were compromised so that they can be notified and affected people can move to reopen their immigration cases. Mm-hmm. And they want an injunction halting deportation of any future Iranian ICE detainees under this protocol until the special master finishes the job. So that is a very, very big ask.
But it's a very important one, right? And I should add, as we conclude the story, the complaint alleges that another mass deportation flight is in the works as we speak, even as the U.S. and Iran have resumed shooting at each other over the Strait of Hormuz.
Yeah, it's amazing how we're bombing this country. Trump is threatening to bomb the country into the Stone Age. At the same time, he's like, and here are all of the refugees.
Here are political prisoners in opposition to the government that we're at war with. It's just, the cruelty is the point. I've run out of ways to say how evil this administration is.
Okay, in a second, we're going to talk about another great villain, and that is Graham Plattner, who is, in theory, resigning from the main Senate race. We will talk about the procedural aspects of his withdrawal when we get back from this brief ad break, unless you are a subscriber at patreon.com/lawncastpod or lawncastpod.com, in which case, no ads for you, not today and not ever. On Wednesday, Maine Democratic Senate nominee Graham Plattner suspended his campaign and announced in an 11-minute, very self-indulgent video that he was withdrawing from the race to unseat incumbent Republican Senator Susan Collins. Get out. Right. There's nothing to say. Get out. As we know, there were credible, upsetting sexual assault allegations against Plattner from multiple women, and his continued candidacy was not viable. And of course, it has sparked this round of circular firing squad with the Democrats who supported him, again, progressives who didn't support him, progressives who did support him. When did people pull out? I'm not sure that that's a useful occupation, but that's what we Democrats do. We do love to punch left. As of the time of this recording, Plattner had not yet formally filed the required paperwork to officially withdraw from the race. He says he will not formally file it until Monday, which is the deadline to drop out, proving once again that he is a selfish dickhead. I'm not sure why he needs to drag this out over the weekend. Just get it done for the good of the people who have to pick up the pieces now, as well as, of course, the voters.
Yeah. As of now, it looks like there are at least 5 serious candidates to replace Plattner as the nominee, and we're going to talk about what that means. It's not a formal candidacy in a minute. Those are Secretary of State Shenna Bellows, former State Senate President Troy Jackson, Nirav Shah, the former Maine Center for Disease Control and Prevention Director, and 2 other former high-level candidates, Dan Klebon and Jordan Wood. So what happens now, assuming Plattner gets it together and officially drops out? The operative statute is Section 374-A of Title 21-A of the Maine Revised Statutes. And what it says is that after Plattner's paperwork is filed, the Secretary of State, the aforementioned Shenna Bellows, who would like to be a candidate, quote, declares a vacancy in the party's nomination for Senate. And under the law, since we're more than 70 days from the general election, that 70-day deadline is August 24th, 2026. So this is more than a month before that. The law says that the candidate's name, Plattner's name, must be stricken from the November ballot.
The law then says that the political committee may make a replacement nomination if the candidate withdraws on or before 5 p.m. on the second Monday in July preceding the general election, which is, as we said, Monday, July 13th. Then the party would have until July 27th to name a replacement candidate.
Yeah, slight rabbit trail. That Maine law also says that if the candidate dies or suffers a permanent, debilitating, catastrophic illness that would render it impossible for the candidate to perform the duties of the office sought, and they file a doctor's note to that effect, then the party can replace that candidate as soon as practicable.
Oh, interesting.
Yeah, even if it's, on the eve of election. And Maine is also one of 2 states, along with Alaska, that uses ranked choice voting. There's a really fun deep dive to this aside on why Maine has to use it in the state primary, but the federal general elections. But okay, that'll have to be for another time. But my point on this aside is that there will not be shenanigans. There are no lawsuits. There's nothing where the Republican Party can get Graham Plattner's name to stay on the ballot and dilute the Democratic votes, or that's not going to happen. And even if it did, ranked choice voting would solve for that. Ranked choice voting for the win.
Okay. On Wednesday, the party held an emergency meeting and its members voted to hold a nominating convention to pick a replacement, with details TBD. Politico reports that the convention would include roughly 600 people who would be selected by county-level Democratic committees, and that every county committee would have to meet prior to the state nominating convention to elect 500 of those delegates, and the 100 current state party committee members will also serve as delegates, which sounds fair to me.
Well, potentially geeky due process point, right? Mm-hmm. The law, right, Section 374A, does not require the Maine Democratic Party to use any particular process to name a replacement candidate, right? Like it is free under the law to just pick somebody, right? They could say, by fiat, we're going to put, I don't know, Troy Jackson.
Well, that's who Plattner wants, and that seems to be the one that would be the easiest substitution.
I think that's right. But I think there's probably 2 kinds of political fallout explaining why the party doesn't just do that by fiat. I think both of them have their roots in the 2024 election. Does a lot of second guessing to pick up on your point from before, particularly after Kamala Harris lost, about, her having replaced Joe Biden on the ballot without a separate primary. I think those arguments are very, very dumb, but they happened.
Yeah, the law and the DNC procedures were clear, right? Harris stood in the shoes of Biden when he withdrew. I mean, this is not that situation, right? Doing anything other than having Harris become the nominee would have been legally dubious. And I think it wouldn't have made it any better, right?
Yeah.
As I said, Democrats love to punch left, right? I do not think inserting another round of Democrats kicking the shit out of each other would have led to a
stronger nominee.
Right, or a better outcome in 2024. I mean, look, it's easy to look back in hindsight and say we should have tried something else because she lost. But at the time, that seemed the most sensible path forward. And I think it probably was the most sensible path forward, even though it didn't succeed.
Yeah, I strong agree on all parts. But that second guessing, I think, is one part of the backdrop. And the second thing that I think is related is that the Graham-Plattner-Janet Mills primary tapped into more than just the progressive versus centrist debate, right? Like Plattner courted the progressive vote, racked up high-profile progressive endorsements. Mills positioned herself as the experienced centrist, the safe candidate who could definitely deliver that seat, with which, the Democrats absolutely must win if they are going to recapture the Senate in the midterm elections. But also, Mills is 78, right? And I think there is a fair perception on the left that the old guard of Democrats remains not prepared to fight in the age of Trump, right? To paraphrase Antonin Scalia, MAGA is bare knuckle brawling, and we're still out there playing by the Marquise of Queensberry rules.
I guess I think that's not a fair criticism of Janet Mills. Janet Mills has in fact stood up to Trump, protected trans kids in the state, was singled out by Trump at a dinner, I think, or a lunch for governors. And she said, I'm not going to do what you tell me to do. I mean, I don't think that she's weak. Look, the question is one of electability. To me, I think she would be a terrific candidate. Although, as I agree, 78 she's not a spring chicken. But whether I think that she was capable of doing the job or not, clearly the voters in Maine did not. And so she's not putting her name forward anymore for this. There are, as you said, all of these other younger candidates who, many of whom were on the ballot to replace her. I think Shannon Bellows was on the ballot to replace Janet Mills, who is term limited out.
Yeah, I'm glad you made those points about Janet Mills. But I think those factors explain why the Maine Democratic Party wanted to have this convention, even though they're going to have it in a very expedited fashion, right? Like they wanted to say, look, we are not repeating the mistakes of 2024. But to kind of bring it back full circle, here's the legal implication, right? Like the Maine Democratic Party didn't have to adopt a process, but once they did, right? Once they said, this is what we're going to do, now they have to follow the procedures that they have promised to adopt, right? Like, and it could, I hope not, but it could pave the way for a legal challenge if one of the candidates feels like they got screwed, right? Fingers crossed that everything goes off without a hitch.
Well, thank God that Mainers don't have a reputation for being cantankerous and holding a grudge, because otherwise this shit could really go sideways.
Indeed.
And speaking of shit going completely sideways, on our Tuesday show we talked about two instances where judges in separate district courts are being played off against each other. That's why our Tuesday show was called Judge Fight. We have updates in one of those cases where Judge Sparkle Sugnanan in D.C. said that the Trump administration could not use the Social Security database to bulk verify voter rolls, and a judge in Florida said, hell yes, they can, and indeed they must. So that is a hot mess, which we will talk about in the subscriber bonus. If you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, we would love for you to support the show by becoming a subscriber or by leaving us a 5-star review on your podcast platform of choice. I hope that you guys have a lovely weekend. Get outside. It is pouring here and will continue to be pouring, but maybe there'll be a little sun over this weekend. Thank you guys for hanging out. We'll see you back on Monday with written content and on Tuesday with another show.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.